Let's now begin our review of the California Council for Interior Design Certification. Let's welcome George Brazil, Board Chair, and Rose Wiebe, if I pronounced that correctly, Executive Director. Please proceed.
Thank you. I wanted to start by saying thank you to the committee members and the legislative staff for the opportunity to participate today. My name is George Brazil. I'm the current chair for CCIDC. I'm a past president of the California North chapter of ASIP, the American Society of Interior Designers. I'm the co-owner of Ccidc Brazil Design here in San Francisco, and I've been a practicing interior designers for the past 30 years. I wanted to start off with a brief history of CCIDC. On January 1st, 1991, Chapter 3.9, Section 5800 of the California Business and Professions Code was created by Senate Bill 153, authored by Senator Craven, codifying a Title Act for certified interior designers. The statute laid out the education and work experience requirements, along with a yet-to-be-determined examination for individuals to become certified interior designers, and the definition of an interior design organization to provide administration of the Title Act. Per Senator Craven's letter dated December 1991, the intent of for the Title Act was a means by which the public and local building officials could easily identify competent professionals to work with building, life safety, flammability, and disabled access codes issues for interior spaces. Based upon this statute, the interior design profession in California developed and created a nonprofit board, the California Council for Interior Design Certification, modeled after state boards to oversee the administration of this Title Act as required by the legislature. The board is charged with verifying education and experience requirements for those who apply to become certified interior designers, determining and approving a suitable and appropriate California examination, and maintain a database of those who become certified. As of September 2021, CCIDC has certified 5,154 individuals since 1991, of which 2,455 are still active, mostly in the state of California. Our mission is to establish and implement professional standards and educational requirements, educate the public, and facilitate interior design professionals' compliance with our standards and code of ethics in order to provide for the protection, health, life safety, and welfare of the public by administering the Certified Interior Designers Title Act. As part of our board's mission, we ensure that those who become certified interior designers meet the statutory standards of competency by way of education, experience, and examination. We establish the measurement standards of competency for experience and examination for those who become certified interior designers. We empower consumers by providing information and educational materials to help them make informed decisions when hiring an interior designer, certified or otherwise. And we empower interior designers by providing information on how to become certified interior designers in California in accordance with the requirements of the Title Act. And finally, providing forums and presentations to interior design school programs, students, and interior designers in general on the requirements and benefits of becoming a certified interior designer. Some of the challenges to certification, the largest barrier to certification or the interior design profession as a whole is the issue of interior designers being able to submit non-structural, non-seismic interior design plans to local building departments for permit approval and acquisition purposes, because they're being denied access to the permit process without an architect or an engineer stamp. Building departments in Los Angeles, San Francisco, San Jose, and Sacramento regularly deny interior designers the ability to submit non-structural, non-seismic interior design plans for permit approval and acquisition purposes. Recent programs such as the Los Angeles fast track process prohibits anyone from submitting plans that do not have an architect's or engineer stamp, excuse me. Without the ability to submit plans per the law, Building Professional Code 5537, 5538, and 5805, building departments are creating barriers to certification and the interior design profession in California. These barriers are considered prejudice in nature, and the interior design profession in California is largely comprised of women and members of the LGBTQ+ community and minorities. According to datausa.com, NCARB, Zippa.com, and the U.S. Bureau of Labor Statistics, 76.3% of interior designers are women, compared to 19.2%, which are men. 24.4% of architects are women, compared to 68.8%, which are men. And 9% of building professionals are women, compared to 83%, which are men. And finally, the language changes we have proposed will clarify for the public and building officials the scope of work interior designers have been doing over the past 30 years, per Senators Craven's original intent. And thank you.
Anything further before I turn it over to questions by members in the chamber? Ms. Wiebe? You're on mute.
Apologize. Committee members, legislative staff, and guests, my name is Rose Wiebe. I'm the Executive Director of Ccidc, the California Council for Interior Design Certification. I appreciate your time and consideration to let us address the issues that were presented to us in the background paper. First, the staff recommendation for us to address how we are complying with the Bagley-Keene Act. The Bagley-Keene Act is provided to all of our new board members during their board orientation meeting in the board orientation binder. During the new board member orientation, we covered the act, and the board members are asked to sign an acknowledgement that they have received the Bagley-Keene Act, understand it, and will comply with it. If there's any questions from them at that time, that's when the Bagley-Keene Act is addressed. We make every effort during our meetings to ensure that all of the requirements from the Bagley-Keene Act are met. Issue number 2, stamp acceptance. First off, the title laypersons, individuals who are not licensed, registered, or design professionals, CCIDC believes that certified interior designers should not be considered in this group within the above definition, who practice under the exemptions of Business and Professions Code 5537 and 5538. CIDs are vetted for education, experience, and tested on California codes and Title 24 regulations, along with California laws and statutes that are relevant to interior designers and have a specified amount, again, education and experience. CIDs should not be considered laypersons. They are design professionals. It should be pointed out that the only group that has any say on who may or may not submit plans for the permits are the building officials. Building officials are not licensed by the state and therefore have no oversight other than the purview of the individual cities and counties they work for. While many building departments are conversant with the CID law and accept non-structural and non-seismic plans, there are several who do not because they feel the only viable option is to accept plans only from licensed architects and engineers. Building officials have stated that if the language in our Title Act was clarified with what CIDs do, they would not have a problem with plan submissions. This is the goal that would benefit the design profession in California. Stakeholders meetings have not yielded results due to the fact that certain parties have only their agenda in mind, and it makes it difficult to work with finding a compromising solution. CCIDC serves the interior design profession as a whole and is focused on improving plan submissions for everyone that we serve. Currently, there are 7 design-related professional organizations. AIBD, the American Institute of Building Design, has 4 CID members. ASID, American Society of Interior Designers, 412 CID members. To note that 89 of those are professional members having passed the NCIDQ. Designer Society of America, we do not currently have any CIDs listed. Interior Design Education Council, we have 6 CIDs listing membership. Interior Design Society, we have 26 CIDs. International Furnishing and Design Association, 14 CIDs. And the International Interior Design Association, 238 CIDs are members. Of those, 106 are professionals having passed the NCIDQ. NKBA, which is the National Kitchen and Bath Association, we have 88 CID members. And the United States Green Building Council, 24 CID members. We also represent 1,261 CIDs who do not belong to any professional organization. Of those, 74 state that they specialize in commercial interior design. Of the 2,400 certified interior designers, 824 belong to one or more professional organizations. The rest do not belong to any. 2 of these organizations are only willing to work with CCIDC if CCIDC is to give in to demands, as such as only using the NCIDQ as the required test for certification, and also requiring more control of the CCIDC board. During the strategic planning meeting where this commercial designation was created, leaders of both of these groups participated in creating the guidelines for the designation and agreed to it. 2 days prior, before the commercial designation being presented to the board, a demand letter was sent saying they would only support commercial designation if CCID agreed to only use the NCIDQ and place 3 new board positions with members from their organization on our board. The CCIDC board reminded them that every organization has equal representation on our board and that inequities of the NCIDQ as certification exam for California have already been proven. Any additional certification, title, registration, or licensure will have no merit unless there is a strengthening and clarification of the law that is currently in place. This title will not allow anyone to do any more work than what was allowed under the exemptions of 5537 and 5538 of the Architects Practice Act. Regardless of interior designers' credentials or examinations they have passed, the review and approval of construction documents will always be under the purview of the building official. Holding the commercial certified designer title out to do so is ill-advised and would result in further frustration to California interior designers and building officials alike. Again, may I state that the commercial interior designers, they're the same with architects. There's no such thing as commercial and or residential. Interior designers may choose that path of business, but they would change as in when the current pandemic happened, a lot of the interior designers who were put out of work for commercial went back to residential. When there was a recession previously, it was the opposite. There wasn't a lot of residential work, so people changed to commercial. So there is no hard, fast, I am a commercial designer or residential designer. AIA has shown in no uncertain terms that they will not support the clarifying language in the CID legislation. Initially, it was because of the issue of safety of the building. Then their concern changed to the new definition of seismic. We were told that if this is the work designers want to do, that they should go back to school and become architects. Again, with a predominantly women-led industry, that's a very prejudicial statement. CCIDC will, however, continue to work with stakeholders in an effort to improve the benefit California's interior design profession as a whole. Issue number 3, the commercial designation. Again, CIDs are at the mercy of individual building officials and their policies regarding plan check acceptance and permit issuance. Every building department is different, and as building officials come and go, their policies may change. The only way to change this is to strengthen the current CID law by adding previously proposed language allowing CIDs, especially those with the commercial designation, the ability to do horizontal exiting in accordance with the CBC. The AIA and perhaps others will push back on this recommendation, even though there are many building departments and officials that allow this.
I think you have one more. That is the
Yes.
contract issue, issue number 5.
The contract, yes.
We can ask,
we have two.
we can simply ask questions if that would make it easier.
On the contract issue, CCIDC is the only board in the country that has specific contract information and contract requirements written into a statute for interior designers. Other states may require a contract, but they don't say what kind and what protections should be in it for the consumer. Non-CIDs have convoluted or no contract at all, so trying to protect the designer and not the client or the consumer. So we do have it in our statute. If a CID were found not to be using a contract, this is something that would be brought up for with the board as a violation of the Code of Ethics, and they could lose their certification.
Okay.
Okay.
Members, Chair Berman, you've been waiting patiently.
Thank you, Chair Roth, and thank you very much for the presentations. This might have been covered. I might have missed it, and I know this is. I know this issue was talked about, but in specific about the CID stamps and plans being rejected by building officials. Do we have any data on how often that's happened, and what remedies, if any, are available to certified interior designers when that does happen?
We don't have actual data because it's not reported to us every time that it happens. But what generally will happen if a CID is to have their plans pushed back and have to hire an architect, this means that the architect has to redo the work altogether because an architect cannot stamp another person's drawings. It causing considerable cost and time delay for the project.
And are any remedies available to certified interior designers when this does happen, or do they just have to kind of accept the building official's decision and act accordingly?
They have to accept the decision. What generally will happen is certified interior designers will call our office if they have a plan check denial. We have a great working relationship with a lot of the building officials. We can contact them, have a conversation. There are times when it is new plan checking staff that have not yet been educated. CCIDC works hard to work with the CALBO and the local ICC chapters to educate building officials, but until they all are, until this is clear, the language gets clarified, this will be an ongoing issue.
Thank you very much.
Thank you, Chair Berman. Let me just ask a couple before I turn it over to my colleagues. The Bagley-Keene Open Meetings Act requirements, I'm not exactly sure from the testimony today what exactly it is the council does to ensure compliance with Bagley-Keene, so I'm not going to belabor it here, but what I'd like to see is a written submission to the staff of both committees as to your efforts to comply, which is, of course, to make sure that you publicly notice meetings at least 10 days prior to the meeting, post agendas, and a whole variety of other requirements that are specifically listed that do apply. So if you could prepare that submission. As you know, the background paper cites to the fact that your current bylaws, apparently current bylaws, do not seem to track with the requirements of Bagley-Keene. So
Okay.
I'm sure you probably do, but it's not clear to me, and it may not be clear to my colleagues on the committees, and we'd like to make sure that that happens before we move forward with Sunset. On the issue of contracts, I haven't specifically pulled the Business and Professions Code section that's referenced in the background paper to check, but it recites the fact that a written contract is required. So what is it exactly that the council does to ensure that individuals subject to the council do enter into written contracts with clients?
Certainly. This is something that when they sign their application form, this is something that they're shown as required. They're given the guidelines of what their contracts are. The issue comes when there are certified interior designers that work for large corporations. Those corporations will be the ones doing the contracts, not the certified interior designers, and a large population of our certified interior designers work for these corporations. But we do monitor this based on complaints. If there are complaints, then they're brought up before the board and could lose their certification. But we've had no such complaints regarding contracts. So other than us educating them, giving them the information, them signing that they understand that until a complaint is received, there's no further way that we can enforce it.
Well, thank you. That answered the question. You addressed the issue having to do with the 83 complaints referenced in the background report, and I appreciate it. Members, any questions, comments, or concerns? I see no microphones up, so let's move to testimony from members of the public about the California Council for Interior Design Certification. First, let's begin with witnesses in the gallery. We have a witness in the gallery. Please identify yourself for the record. You may proceed. Thank you.
Thank you. Good morning, members. My name is Laura Taylor. I'm a commercial interior designer, and I represent the Northern California chapter of the International Interior Design Association, or the IIDA. Specifically, I want to comment on the commercial designation, which was mentioned. So I want to support the designation of a commercial interior designer. It was mentioned that there is no difference between a residential and a commercial interior designer, but then why designate the difference? As a commercial interior designer, it is a distinct scope of practice. We practice in the code-impacted environment. So we work on projects like airports, hospitals, workspaces, restaurants, all of those things, a diverse array of projects. And we work alongside peer professionals, so architects, engineers, landscape architects, who all have stamps that give them expanded practices. And as it was mentioned, we have an issue with our stamp acceptance, but we also don't follow the same certification structure that those peer professionals do. So those peer professionals sit for a national standard exam. Then they sit for a California supplemental exam, and then they receive state certification with those expanded privileges. So the NCIDQ, which was mentioned, is the national standard exam for commercial interior design competence, and that exam is not required for a CID or for the commercial designation. So for us, what that more typical structure of our peer professionals might look like would be sitting, after education, sitting for this national standard exam, sitting for a California supplemental exam, which could be the existing IDEX exam. It covers important topics, California code, safety issues that are specific to our state and very important. And then receiving a state certification that gives us those expanded practice privileges. I don't think that we want to make a comment on anything in the CID that works well for residential designers or other designers. If the certification works for them, that's fantastic. I want to recommend to this committee and to the legislature to take some time to review this certification and make some meaningful progress on the issues of stamp acceptance and testing that have come up several sunset reviews in a row. And I want to offer the Interior Design Association, myself, as a resource for questions and context. And I'd like to ask that we not extend for another 4 years the certification that is clearly not working for some commercial interior designers like myself, and instead make some meaningful progress through further conversations. Thank you.
Thank you for taking the time to come and provide your comment, and we will attempt to address that issue. Any further public comment in the gallery? I see someone approaching the microphone. Sir, please identify yourself for the record and proceed.
Hi, folks. How's it going? My name is Adam Newton, and with my colleague Laura, I am also here speaking on behalf of IADA Northern California. I work as a project manager for Sutter Health. I'm actually extra happy to be here today because my territory is to manage Sutter's buildings and capital projects in Assemblymember Berman's district. He's down there. Hi. I am trained and educated as an architect, but chose to practice in a commercial interior design scope, specifically doing healthcare interiors. It's a little braggy, but I like to say if you've been in a hospital in the Bay Area, you've likely been in one of my projects or at least used one of them. The placement of walls and ceilings, specification of fire-resistant fabrics, the design of your local hospital emergency or delivery rooms, and even your kid's classroom are all things an interior designer is qualified to do. And this work, the work that we do, has helped elevate California's interior spaces to lead the country in sustainability, accessibility, and fire and life safety. Despite this, though, interior design is the only design profession in the state without a national standard exam and a regulating state agency. As someone who's practiced in architecture, interior design, and now as an owner's rep, I can tell you interior designers have a unique expertise to create functional and meaningful spaces. When I worked on affordable and homeless housing projects, it was my interior design expertise that led me to propose additional insulation for walls to help veterans who could experience auditory triggers for loud urban environments. It was also my expertise that helped plan a psychiatric emergency unit with built-in flooring indicators to indicate safety thresholds for staff when dealing with complicated patients. As you've already heard today, this profession is led by women, members of the BIPOC community, and LGBTQ people. The lack of standardized privileges that align with our peer design professionals, like architects or civil engineers, makes it just that much harder to compete economically and professionally. As a member of the queer community myself, I strongly believe that the lack of standardized, codified privileges facing our profession is of incredible importance to correct. And if there's one big thing I want you to all take away from this, it's that commercial interior designers want proper legal regulation and privileges for the work that we are qualified to do and actually are already doing. I respectfully ask this committee to, like my colleague Laura said, take a progressive step and grant an extension of time for this profession to be thoroughly examined instead of just kicking the can down the road another 4 years. Thank you very much.
Thank you, sir, for your time and your comments. Any further witnesses in the gallery? Seeing no other witnesses, let's move to witnesses waiting to provide public comment through the teleconference service. Moderator, if you would please prompt any such witnesses waiting to provide testimony about this particular council, we shall proceed.
Thank you, Mr. Chair. Ladies and gentlemen, to provide comment, press 10. You'll be provided with your line number. And when your line number is called, state your name and affiliation for the legislative record. We go now to line number 11. Your line is open. Go ahead, please.
Thank you, Mr. Chairman, members of the committee. Mark Christian with the American Institute of Architects, California. AI California supports extending the sunset date for CCIDC. That's because CCIDC does provide a benefit to consumers. Interior designers and anyone else, any other unlicensed person, can provide design services under an exemption in the Architects Practice Act. That exemption allows anyone to provide design services for non-structural and non-seismic work and work that does not affect the safety of a building. Work that does involve the design of a structural or seismic work, or that does affect the safety of the building, it has to be prepared by an architect or an engineer. This is long established law. So for the exempt work, CCIDC provides a benefit to consumers. A consumer knows that someone who is a certified interior designer is an individual who has demonstrated competence through the 3 E's: education, experience, and examination. That's a value to the consumer and why we support extending the sunset date on the law that allows CCIDC to certify interior designers. Also like to point out some information that hopefully you'll find pleasing. About 50% of students in architectural schools today in the United States are women. More women are entering the profession of architecture, and we look forward to the day where there is complete parity in the practice of architecture. Thank you very much.
Thank you, sir. Moderator, next, please.
Next, we go to line 13. Please go ahead.
Chairman Ross and Chairman Berman, members of the committee, thank you for the opportunity to speak to you today. My name is Matthew Baruch, Government Affairs Manager for the Council for Interior Design Qualification. And to the written comments submitted by our CEO, Tom Banks, in support of the International Interior Design Association's request for collaboration, I would like to submit the following clarifying comments, as there has been a great deal of mention of the Ccidc in the background paper and in today's testimony, so I would like to provide the committee with the facts. The Ccidc exam is the national standard for competency assessment in interior design. The Ccidc exam is the prerequisite for a certified interior design registration or licensure in 30 U.S. jurisdictions and all Canadian provinces. State legislatures recognize the Ccidc and continue to do so and utilize the exam as the basis for reasonable regulation, exemplified by the passage of North Carolina's Title Act last year and by legislation establishing permitting privileges that is currently moving in Wisconsin, Illinois, and Iowa. Language which has all been agreed upon with each state component of the American Institute of Architects and creates the exact kind of clarifying language that Ms. Weeb spoke of and that building officials are requesting. The state of California has unique needs in regulating the design professions due to its state-specific building codes and standards. That is the most frequently cited reason against utilization of a national interior design competency assessment, and it's the state's prerogative to decide how to address those needs. That is how the state of California came to require California supplemental examinations, in addition to national competency assessments as requirements for licensure in several other regulated professions. This model appears to have worked for California in allowing its workers to enjoy the benefits and rigor of a known certification while ensuring that safety of the public continues to be protected and the unique needs of the state are met. There is incongruity in how the state regulates the design professions. The model of a national competency assessment with education and experience requirements utilized in conjunction with CSEs is how California regulates all other design professions, including architecture, which has distinct similarities with interior design. Only interior design does not have this model. It has been well documented that there are many areas of correlation between the professions of architecture and interior design, including required areas of competency and professional knowledge and skills that are similar and in some cases, substantially identical. Recent research conducted by Ccidc and the National Council of Architectural Registration Boards shows significant similarities between our respective practice analyses and exams. A group of subject matter experts from both organizations found that 83.3% of the objectives and knowledge areas of the Ccidc exam had definite or some similarity to objectives and knowledge areas of NCARB's architect registration exam. That is not to say the two exams are the same, they are not. The Ccidc is the national certification for interior design, just as the ARE is the national licensure examination for architects. They both sufficiently and adequately assess competency and the scopes of practice of each profession, which, while distinct, does carry many similarities. The state of California does currently utilize the ARE, but not the Ccidc.
Sir?
And finally, I would also like to state that we have all the same intent and goal with this issue, the public protection of the health, safety, and welfare in the built environment. I will conclude just by saying that these facts bore out a simple reality. We agree with earlier testimony that the state of California should critically re-examine the Certified Interior Designers Title Act and how it regulates the profession of interior design. Not doing so does a disservice to a predominantly female profession. The state of California has not revisited this framework since the passage of the initial law in the 1990s. Myriad developments in not only the interior design profession, but regulation as well have taken place during that time. These developments include several states that have passed legislation granting certified interior designers stamp and sealing privileges, establishing joint boards, and in some cases providing permitting privileges, all on based on the passage of the Ccidc.
Sir?
Not only is this current...
Hello?
Yes.
You have now moved.
Can you hear me?
Yes, I can, very well. And you're now moving to 5 minutes, which is almost 3 times.
We'll conclude my.
Well, let me just say this.
My apologies.
Normally, the detail that you provide is not the kind of detail we take in public comment, but I'm delighted to do so. But if you want your rather detailed comments that appear to have been reduced to writing considered by the committees that are conducting this joint hearing, I would suggest that you submit your comments, the written ones that you have, to committee staff so that they can be fully considered as we move through this joint sunset review process on this particular council. So 30 seconds concluding statement.
Thank you, Mr. Chair. We have indeed done so. And to be clear, nobody is suggesting that CCIDC should have no role in regulating interior design. We are not suggesting that we do away with the IDEX. An obvious solution exists when it already is implemented by the state and could be utilized for interior design. CIDQ would happy to be a resource for the legislature on these issues, and I'm happy to answer any questions you might have.
Thank you very much for your comments. Mr. Moderator, next.
Next, we go to line number 24. Please go ahead.
Good morning, everybody. My name is Christine Peter. I represent Southern California IIDA. As a commercial interior designer and a small business owner, also as an owner's rep, I've been successful in utilizing my designer plans for commercial projects. But I do have colleagues who regularly have their plans rejected simply because we are not formally designated as design professionals with stamp authority. One of my colleagues actually had to hire an architect full-time to her staff. This person had less knowledge and experience than she did, but it did allow her to have her design drawings be submitted and approved easier. This process added cost and time to the design project and also to the end user project as well. This makes no sense. I know at any time my luck could change and I will be put in the same situation. While I appreciate CCIDC's acknowledging that the commercial interior design certification has a place and currently has issues, they have attempted to define a path for commercial interior designers. Unfortunately, it is not effective and it has not solved the problems that we are currently facing. Our ask is for a short extension of 1 year prior to another full year approval. We'd like this to allow us to resolve the unsolved issues of stamp acceptance and commercial designation. And we, as IIDA, would like to come to the table and help them with the committee staff and the stakeholders. Thank you.
Thank you very much. Next, please.
Next, we go to line 22. Please go ahead.
Yes. My name is Linda Panatoni. I'm Interim Director for the California Legislative Coalition for Interior Design. I've been involved in the profession of interior design for over 30 years. And I would like to just make a few points. CCIDC focus has always been on, as long as it's been in existence, for the health, safety, and including the development of a strong relationship with the building department. And I would highly encourage acceptance of the clarifying language to make it easier for all designers to practice. CCIDC is not generic like the NCIDQ exam. The NCIDQ exam continues to be promoted by IIDA and ASID as the only exam that tests the competency of a residential or commercial designer. But the NCIDQ does not test for the California codes, the Cal Green, Title 24. The CCIDC exam, the IDEX exam, does just that. Number 3, CCIDC initiated a commercial designation. This designation was worked out with the CALVO and the International Codes Council, and this designation requires more education in commercial design designer is now required to pass at least 5 additional courses specifically designated by the International Codes Council in order to get that commercial designation. There is no need for further review for an association or a council that already provides everything that's needed for an interior design degree and certification in both commercial and residential. Thank you for your time.
Thank you. Please submit your, if you have them in writing, your comments to committees, staff members for our consideration. Moderator, next, please.
Next, we'll go to line 25. Please go ahead.
Hello, my name is Nicole Deline Grant. I am IIDA Southern California VP of Advocacy and a job captain and senior associate at HLW, one of the oldest architectural firms in the United States. I have 20 years of construction experience, and my primary professional role is providing documents to plan check, the very role that we are speaking of. Commercial interior designers, especially new professionals, are confused by the certification structure because it's so widely different from our peer professionals, like architects, landscape architects, and engineers, who take a nationally based exam and a California supplemental exam to become registered through the DCA. However, interior design certification and registration in other states utilize a national exam as the basic exam and also require a supplemental exam for California. Then upon the passing of the exams, they are granted a stamping and signing privilege to take to the plan check department. We think the state can and should do better for interior designers. We are not granted stamp and seal privileges under most jurisdictions. In fact, I've personally experienced this issue when I've taken plans to the city. They expect me to have a male colleague come with me to plan check and speak on behalf of the technical field that I've been working in for 20 years. The CID works very well for some interior designers and decorators, and we should have a thoughtful discussion that considers those professionals who design commercial spaces and ensure California licensing and oversight is appropriate and reflects the current profession. We thank the committee and your staff for identifying the 2 current issues, that stamp and seal acceptance is an issue and commercial designation is a problem. However, these issues have been unresolved for now. IIDA would like to work with committee staff and with stakeholders over the next year to make significant progress that would help us all. Our ask is for a short extension of time to do so for another year for approval. Thank you.
Thank you. Moderator, next, please.
And we have no one else in queue at this time.
Thank you, Ms. Moderator. Having heard public testimony, members, are there any other questions, comments, or concerns about the California Council for Interior Design Certification? I see no microphones up, so let's move on to the California Board of Occupational Therapy.
Excuse me, sir.
Yes.
I can't find the raise my hand. If I may respond?
Well, let me just see. Oh, I'm sorry. I apologize. Yes.
Any apologies, a couple of things. First off, the commercial designation does require
we typically don't have questions, comments, or responses to public comment. Is this something that you feel compelled to do at this point in time?
No, thank you.
Thank you. Sorry, I didn't see you on the screen. We were moving on to the California Board of Occupational Therapy. Let's welcome